But good morning, everyone. Welcome to the Fighting for Housing and Community Justice, the Role of Lawyering in the Movement panel discussion. My name is Lina Lee. I am a co-founder and executive director of Communities Resist, a legal services providing free representation for low-income tenants across Brooklyn and Queens. I will be the moderator today. And before we begin, I do have some instructions for CLE accreditation. So the Asian American Bar Association of New York is certified by the New York State Continuing Legal Education Board as an accredited provider. This program has been approved in accordance with the requirements of the CLE board for a maximum of 1.5 credit hours, in which 1.5 credit hours will be applied toward the areas of professional practice requirements. This program is suitable for both transitional and non-transitional New York attorneys. You must have pre-registered and confirmed for this program to receive CLE credit. The first page of the written materials that were emailed to you is an attorney affirmation, which you must complete and return to cle@abney.org. Codes will be announced during the program. Record the codes on the attorney affirmation. Please return your affirmation as soon as possible within 1 week so that we can send you your certificate. You received a link for an online evaluation for this session with the written materials. Please kindly complete the evaluation so that we can improve our programs. This program is being recorded. Your continued attendance in this program constitutes your consent to transmit, record, and use your voice and image for this purpose. So about the 9:25 mark, I will read out loud the first code. So why don't we get started? So I want to introduce to you our two panelists. Gregory Lewis, he is a co-founder of Communities Resist, an associate professor of law at CUNY. Shekar Krishnan is also a co-founder of Communities Resist and a city council-elect for District 25. And today we will be talking about the role of community lawyers in fighting and defending poor neighborhoods of color from displacement. I'm just going to briefly allow Shekar and Greg to introduce themselves. For the remainder of their bios, you can find in the written materials.
Go for it, Greg.
Good morning, everyone. As Lina indicated, my name is Gregory Lewis, and I teach law at CUNY School of Law, sort of specialized these days in business law topics, contracts, corporations. I also teach matters of material or municipal corporations, New York City law. Sort of that is rooted in about a decade of practice in community lawyering in the New York City area, principally Brooklyn, of course, with Lina and Shekar at Communities Resist, where we co-founded. We also work together at Brooklyn Legal Services Corporation A. And before Brooklyn Legal Services Corporation A, I worked at Legal Services Hudson Valley, at all times working with tenant associations, shareholder associations, collectives, in the community housing context. Part of the motivation for doing that is I'm the son of Haitian immigrants from the New York City area. And that sort of background, that sort of experience has sort of framed a lot of my professional thinking and a lot of what I've been able to practice. So welcome, I'm very, very glad to meet you all. Shekar, I'll pass it on to you.
Good morning, everyone. My name is Shekar Krishnan. I, along with Lina and Greg, one of the co-founders of Communities Resist, we are longtime colleagues and close friends, and it's such an honor to be on this panel with both of them and all the work that we've done together. So as Lina mentioned, after being in legal services for a long time and our work together, I actually the Democratic nominee for City Council for District 25 in Jackson Heights and Elmhurst, Queens, which proudly one of the first South Asians ever to be hopefully elected to the city council in the history of New York City. And one of the first AAPI council members in a class that we have as big as ours of 6 AAPI incoming council members. So it is very both a special and unique moment and also a moment of pride to be on this Albany panel in particular, given this moment right now in our government and our politics too. But just by way of background for myself, I am a son of immigrants from India. And that's always, as Greg mentioned too, that's always been such a formative and motivating part of my work and my desire to get into legal services and housing justice in the first place is seeing the struggles, as Lina and Greg will say, and can explain to as well, seeing the struggles of our parents and what they faced, the discrimination they endured their entire lives was certainly a motivating factor for us to even become lawyers in the first place. And then, as we'll talk more about, was, through conversations we've had, the work that we've done over the years, certainly the impact of race and racial justice as it connects to the housing movement was one of the formative reasons that we formed and founded Communities Resist in the first place. But our model of work at Communities Resist is to represent low-income tenants in housing struggles, both in areas of North and East Brooklyn, as well as immigrant neighborhoods in Queens. And we represent, by and large, tenant associations because we strongly believe in the power of combining organizing with lawyering. And we also represent community coalitions that are mobilizing against rezonings that violate fair housing laws or would further gentrification and displacement in the neighborhoods that they're in. So that's, obviously such a critical issue right now in our city. I've always said that the housing crisis is the most urgent crisis because it connects to every other crisis around us in terms of where you live, affecting everything else around you. So we're very proud to be here today and very excited to be on this panel together.
Thank you, Greg and Shekar. So before we begin with the discussion, if you have any questions during the discussion, we have reserved 15 minutes towards the end to answer them. So please use the Q&A button at the bottom of the screen to submit your questions, and we'll get to it at the end. So Greg, why don't you tell us what is community lawyering and what makes it unique?
Certainly, Lina. Community lawyering refers to an approach that often legal services often involves nonprofits, but it's an approach to the content of sort of a lot of legal representation that comes out of a deep engagement and rootedness in a community. Here in New York City, as sort of, Shekar was framing, many of the issues of being part of a community with poverty and low-income individuals are housing related. This is a city of renters, and so it naturally takes that form. But the practice across various communities across the United States, other issues are salient, other issues that are often environmental, other issues that often can refer to sort of low-income entrepreneurship. It's a hodgepodge of actual legal practices because it takes its basis from what does a community require to sort of have social citizenship, actual participation as a sort of sense of a root out of and a resistance to poverty. And so I often like to describe it based on my background as being a general counsel for poor people, in the way that what corporate lawyers do is the answer is everything. They just sort of keep corporations and institutionalized wealth together. Same thing with communities. What do community lawyers do? They do everything to sort of keep communities to sort of address root questions of poverty. And so it's less of a specific practice area, even though, again, as Shekar and as we'll sort of talk about here in the New York City context, housing is salient based on the basic structure of our city, but it's much less practice area oriented, and it is more a practice, a mode of treating communities, low-income individuals, as one would treat corporate counsel. or the general counsel of a corporation is a representative, or corporate representatives, as the goal is to keep individuals empowered, is to keep people together, is to keep people sort of present. And sort of, I think the last part that's also in that sense tricky, right? It's not just the practice area, but a lot of the aim is something of a negative. It's where things do not happen, or if you want to sort of frame them affirmatively, it's where people are able to be kept in place and are capable of being able to strive, that community lawyering is accomplishing its aim. It's not any specific outcome like winning a specific eviction case, or winning a specific piece of anything. It's the long-term way of ensuring that communities can strive, communities can stay in place. So that is the focus of the practice.
And I think, okay.
I'm sorry, go ahead, Shekar.
No, I was just going to say, I think to Greg's point, and by the way, sorry if you hear some random children's noise in the background. They're making noise once in a while. But, I think to Greg's point about the work that's involved, just to zoom out for a second too, and talk about, as I was mentioning before, in New York City, the housing crisis over the last 20, 30 years, there's been such a shift in the focus of this crisis. It's always been going on. These are neighborhoods, to Greg, as Greg mentioned before too, that we work in, whether it's Williamsburg, Bushwick, or Flushing and Jackson Heights. These are neighborhoods that have historically and systematically been disinvested in for decades, right? You think about back in the 70s, these are the neighborhoods that were at the center of white flight, and notions like the Bronx is burning. Landlords would be burning down buildings to collect fire insurance in neighborhoods that they didn't want to be in at all. Fast forward, and then of course, during that time period and going forward, you had REBNY as such a powerful, and developers as such a powerful lobby in New York State, passing laws and legislation that was ensuring that apartments could as quickly as possible be taken out of any form of rent control or rent regulation and becoming market rate as quickly as possible. So you look back at those laws and the schemes that we're operating under, and you just see how uneven the landscape was, and how much in favor it was of special interest real estate forces. And that's on the legal level at the top, but that trickled down very much so to the work that we were doing on the streets every day, and the way in which the laws that we were navigating. There were two major problems. One, the laws are very much not on our side through the 90s into, I would say, as recently as 2018 or 2019, the laws were not on our side. On top of that, the tactics of collecting fire insurance, landlords burning down buildings, collecting fire insurance, are still tactics that continue to this day too, but for very different reasons, because these neighborhoods that were once systematically disinvested in are now neighborhoods that are at the height of gentrification and displacement. So, but the tactics by landlords to harass tenants and get them out remain the same, even though the motivations are different now. The motivations being for landlords to keep those buildings, to then turn them into luxury apartments. So you had a legal landscape that was very problematic to us. You had a socioeconomic landscape that was forcing out long-term, low-income tenants of color from these neighborhoods at alarming rates. And then a court system that was as problematic, and still is, because any laws or rights that we had, we found impossible to get enforced through litigation or in the courts, because the courts were very hesitant to disturb the power dynamics that we were combating. And of course, one of the biggest things that we'll talk more about is, no matter what the laws may say on paper, if they're not enforced in reality, if we don't have a court system that will enforce them in reality, then it's extremely difficult as community lawyers to defend tenants' rights. And that's just some backdrop on the landscape that we face.
So we can talk more about the enforcement of these laws, but Greg, can you talk to us more about how housing laws have changed? New York City is supposed to have one of the most progressive and tenant-friendly laws that protects affordable housing. How much of that has changed, and what have you seen in the housing landscape in terms of affordable housing?
Yes. I think, relatively speaking, especially compared to jurisdictions around the United States. New York City is known for having some of the most progressive laws, but I sort of think what Shaker's pointed out to is a two-part dynamic as part of affordable housing. So the first piece of it is, and this I think is particularly salient to the conversation for API communities here in New York. Affordable housing has proceeded, and this is the problem, right? You have a city that's overwhelmingly made up of renters and low income renters. One of the sort of counterfactuals that people who are not from here don't appreciate is this is a pretty poor city, right? Like the area on the whole, the metropolitan area, when you add suburban communities in Nassau or Suffolk or Westchester, and of course, when you add New Jersey, that makes it overall, and Southern Connecticut, that makes it overall appear wealthy, but people who've got typically, overwhelmingly for the most part, people who have resources do not live in actual New York City. People who live in actual New York City are poor. And so you have, despite that reality, you still have a legal system or a legal set of laws that continue to operate on a neoliberal paradigm, i.e. on an idea that we rely on private investment to create affordable housing. And, as folks, anyone in finance knows, it's requiring of individuals to do something that's economically irrational. The cornerstone of that idea is the mandatory inclusionary housing program. That's the primary way over the past 30 years that the city, going back to an idea from the 1980s and affordable housing plans with Mayor Koch, there's always been an idea where we require private side investment to create affordable housing. And the dynamics of the market are such, the word that real estate people use, the pro formas, is you can't really generate through that model affordable housing or housing that is affordable to the poor people who require it, the poor people who've been forced out of communities when they become desirable, sort of highlighting Manhattan's Chinatown as an iconic version that has sort of turned into whatever it's called, Lolita, Tribeca, whatever term that is used du jour, and obviously to sort of highlight the salience of that. Flushing, of course, now, or the 7-line problem of there's another train line that allows relatively easy access into Manhattan that's quick, it becomes desirable housing. So those folks who are forced out, the only model that we have is when we rely on private development, and it's just not, it can't be made affordable. It's just not how private investment works. It can't be made affordable for those populations. So we have an affordable housing system as represented by mandatory inclusionary housing that ignores the needs of people who are poor. One of the iconic forms of housing that exists that are deeply affordable, of course, public housing. New York has had a remarkably precipitous drop in public housing over a shockingly short period of time. As recently as 2008, Nicholas Dagan Bloom issued a book about New York City's public housing, and he sort of praised it as a program that worked. What we've seen at the level of funding cuts from the federal government, so the federal government turning its back, and there being no political will or capacity to, again, deal with a form of housing that is outside of the neoliberal paradigm. That the whole point of public housing, it is social housing. It is government owned. It is exactly what, it's a very old model that we're looking at, advocates and part of political discourse are pushing to sort of say, well, we ought to have European style social housing in the United States. We built that in the 1930s. And we did a lot here in New York City. It's just that there's a lack of political will. And so that housing is in decline, both physically, and I think it's also, there's a loss of sort of just as a general matter, political backing for it, right? The movement with public housing in New York City has also taken a neoliberal course in terms of programs that folks might have heard of in sort of the NYCHA infill, the NYCHA next gen, all of these are ideas to try to say, how can we get private investment capital into public housing? And that is a net elimination of social housing as such. It's selling parcels, where be they parking lots, entire projects over to private developers who will infuse capital, but at the long-term reality that it will no longer be social housing. So the crisis, to sort of crystallize it, is we have a legal scheme that builds what's probably more accurately described as below market housing through private investment. That below market housing is not affordable to poor people, and especially given the dynamic that the poorest group of any demographic in New York City is the API community, another one of these things that lack visibility or salience, right? That community is disproportionately affected by a politics that is not interested or doesn't have the capacity to actually consider what housing that would be affordable to its poorest residents. And so you sort of have a very perverse reality that, sure, the laws compared to, I don't know, South Carolina or wherever other, horrible jurisdiction from a standpoint of inclusion you could pick, but from like a basic democratic reality, it is absurd that a city that is overwhelmingly made up of poor renters have no practical representation in policy. And that's a depressing part, right? Because if it's not here with the demographics and reality of the city, it's not exactly clear where else it could be. And of course, I would highlight other similarly situated places like San Francisco face this problem of sort of like a large poor, native class who have no political resonance, and on paper you have laws that seem progressive, but relative to the needs of the sort of, constituents or the constituency at large is just not responsive.
Before I ask Shekar to jump in, Greg, can you talk more specifically about sort of the unique position that API communities face dealing with affordable housing? And because Queens has the most diverse API communities, how has that affected, and what is the relationship between really the reason why APIs communities really are the most in terms of income level increasing in poverty and having to deal with this housing crisis? And why is it that a lot of these communities, a lot of attention is not put on this, and how do we shed more light on these issues?
I'm going to draw from something that Shekar alluded to. Very simply, and this is the important part, because I would say the root of it is a political representation problem, right? I mean, you have the political representation problem is at the political discourse, in API communities, I think there is the 65 Act myth and invisibility problem, right? Because I think at just a fundamental level, there is a complete lack of recognition of the poverty. And so the sense is, the image of the model minority, that whatever realities of poverty are transitory, that they're overcome with sort of hard work. So it's not considered to be a real problem, in the sense that the assumption is these poor communities through hard work will become wealthy, and boom, they'll go live in parts of New York City that they can afford. And I think that stereotype is held by people outside of the community. It is held by people who would identify as being progressive. And so the lack of general political representation, the fact that we've had a council that does not represent that we've had so far, and the incoming council with the new six new members is changing that matter, but that cannot represent that perspective. And so in policy, there's an invisibility problem that I think deeply affects that. That's deeply affecting how it is that we're to sort of think of this problem. Like, there's a sense that the affordability crisis is uniquely a reality for Black and Latinx communities. And so to that end, the number of units that we would need to generate, or the public housing crisis, can sort of be thought of as, well, as long as with MIH we can generate enough units, or with next gen investments, we could generate enough units to sort of take care of the majority African American and Latinx communities around the city, we're fine. We don't have to think about the API community because, as a general matter, again, that's not like an entrenched generationally poor community. And I think the sort of counter narrative from individuals who are from these communities specifically, represent these communities specifically, who can sort of talk about what Shekar described as a long narrative of disinvestment, who can sort of frame the many overwhelmingly low-income communities, Flushing, Sunset Park. We spoke about Manhattan's Chinatown around New York City, the Bronx, in terms of also South Asian Bangladeshi communities, sort of like the way in which this is more representatively and entrenched, as again, New York City is overwhelmingly a city of poor renters. It's not the aberration. The more representation there is in council, the more that policy can sort of focus on first observing that there's a deep affordability crisis in these communities. It's not an aberration, it's not transitory, and it's something that needs to be wholly tackled across the city. I mean, I would say it's the classic, the short of it is, it's a classic political problem of a lack of representation. And that's why representation matters, because you don't have progressive or so-called progressive academics dictating to your community what is their reality of poverty, based on some sort of absurd stereotype that has never been true, and certainly isn't true here in New York City today, though it continues to sort of dominate political discourse.
Thank you, Greg. So the API community, like you said, is underrepresented and under-resourced and underserved. Shekar, can you talk more about that and what you have seen on the ground? And what are some unique really challenges that you have seen API tenants face in these communities?
Well, I think Greg did a great job giving the background of how we are at this point, and the misperceptions and the stereotypes that we as API communities face when it comes to these issues. The lack of information about the extent of poverty in our API communities, the lack of representation, but also, and this is a critical issue, the lack of language accessibility. A lot of times when we think about government services and resources, especially in the housing context, very few of them are actually translated into the languages that uniquely would impact our API communities. For example, I remember DHCR recently, the number of fact sheets, DHCR or HCR now, the Division of Homes and Community Renewal, has a number of different fact sheets that explain how rent stabilization works, the definitions of the laws. And I think it was only very recently, if not, it's still the case, that only one, maybe a couple max, are translated into Bangla. And that just tells you, when information and the rights that tenants have and the laws that protect them are not actually accessible to them and in our languages, then that means that they're just worth less than the paper they're written on. No one will know them. And then when you live in a world with the absence of information, that's when actors like predatory landlords prey on that to force out tenants and to evict them. So that's the first issue we face, is just a lack of accessibility on the government end. I would also say within legal services, it's an issue too. I remember a conversation that three of us have had, Lina, for example, how you would tell me that there were Korean American tenants in the Bronx who would take the train all the way to Minkwon in Flushing, because that's the only place that they felt comfortable getting services where they knew would be in their language, and they would be able to be represented by attorneys who understood the crisis that they were facing. And I think when you realize that tenants have to travel all over New York City to simply Asian American tenants to travel all over New York City to simply secure legal services. That's a really stark reminder of how little has been invested in not only government resources that are accessible, but in social services that could actually reach our communities as well. And that factors into everything. I was recently helping a Tamil speaking family from South India that I had seen on the street. And they were telling me how they didn't know where to turn to receive services. They couldn't pay their rent. They were living in a basement apartment during Ida and have been displaced from it. And we're now sharing another apartment, but they couldn't pay the rent. Their adult son was here, but they had no ability to seek out help. They didn't know where to go. And in speaking to them, I knew an organization that served the South Asian community that could help them in this situation. But that's only because I had happened to see them on the street and they came forward and they had questions. How many tenants in those situations who desperately need public benefits but don't even know the process of where to start, because putting aside the immense bureaucracy within city government to apply for benefits, don't even know the organization to turn to receive services. And at that, there are probably only one or two in the city each that serve our API communities, each community. And I think that that's the problems of systemic inequity and a lack of representation that we face as API communities that affect tenants. The last piece I would add to it too is that, I think that very understandably, because of the invisibilization of our communities over generations, there is a lot of fear among immigrant community, across immigrant communities, but I also think it affects our API communities, to fight back or to challenge a landlord that may be being very oppressive because of a fear of how that will impact immigration status. Is that a fight that we can actually win? I remember, Lina, a building that you had worked on in Flushing that was largely Korean American, and by virtue of the fact that Korean Community Services had referred a senior tenant to us who only spoke Korean, we got to figure out that there were a lot of Korean tenants in the building that were being harassed, that were being overcharged, and threatened illegally with eviction. And many of them in this building were simply giving up and leaving because they didn't know if they had rights or if they could fight. And the senior that we worked with, and we had meetings with, had said that he was on the verge of leaving too, had he not been connected with us and with KCS together to help him to fight back. And I just think that is something that, is a very systemic issue in our API communities, where so many tenants don't know their rights, but are also compounded by lack of language accessibility, are afraid, and very understandably are like, maybe if we're told that we have to leave, then maybe we should just leave, because if we fight back in any way, that may disrupt the entire system that we're facing, and put us in a very negative spot. It's something that I think all of us, as children of immigrants, know well, with our parents' generation too. And that's also something where I think, we could also learn a lot from the Black and Latino communities as well, is how to mobilize and organize and fight back in that sense too. So, I think that is the different layers of the challenges that API tenants face that, we are trying to combat, and so many other organizations that do similar work to us too.
I want to talk more really about the, and both you and Greg alluded to it, but really the deep-seated, deep-rooted intertwinement between race and housing issues. Before we go into that, though, I do want to read out the code for CLE, and it's Remain 5167, Remain all lowercase, REMAIN 5167. So if Greg, if you can talk more about the history of really the relationship between race, if there is any, with the affordable housing crisis, and how that has shaped specifically New York City and the housing laws that developed around it, and what we have seen and sort of the aftermath of that that we are facing today.
So very simply, the sort of narrative that the trajectory I think that Shekar was sort of alluding to sort of goes like the story sort of goes like this, right? We have the Second World War, and politically in the Second World War, you have here in the United States racial apartheid, right? Stereotypes that govern social relations across a hierarchical dimension. African Americans in Jim Crow, that sort of element. But of course, the great perversity of what a lot of us learned in law school is the concept of strict scrutiny was developed in a case called Korematsu. The irony is the first application of strict scrutiny, which we've always learned means the government will lose, is where the government policy was held as against the Japanese on another one of these, hideous stereotypes about loyalty to the emperor, that sort of, all that nonsense, right? And then we, of course, the Allies encounter the atrocities in Nazi Germany. It's no longer possible to come back, fight, folks over there and come back to the United States and have apartheid. Then you have the material prosperity of the 1950s, the sense where that needs to be shared with groups who are excluded. Kennedy to Johnson, the Great Society. Part of the Great Society is first the 65 Act to try to undo the hideous legacy of racism in our immigration laws, captured, archetypically with or API communities affected, the Chinese Exclusion Act, all of that hideous stereotyping in terms of requiring right witnesses to a system of fairness, right? But again, the study of the 65 Act is allowing the, sort of best and most accomplished Black and brown people in sort of set up a paradigm, an expectation that only those sorts of folks matter. So you sort of now have a sense where the sort of confluence of all of this, individuals who have material wealth, regardless of color, can participate, whereas poor people, regardless of color too, are not left to matter. New York City resists that. New York City takes an actual, genuine in 1960, deeply progressive, inclusive position to try to look at racialized poverty, right? So to that end, 1969, we have the rent stabilization law, which if you look at the preamble to it, recognizes affordable housing as a socioeconomic problem, right? Not purely a racial, it's a racial problem. You have that, you have, of course, the Fair Housing Act in 1968, as Shekar referenced. Dr. King had recognized that housing is at the center of everything. It sort of determines life outcomes. So that sort of becomes part of the narrative. And at that moment, late 60s, that ferment, that sort of, the response to the sense of the class aspect of inclusion that challenges the consensus that we'd come up with as a nation at the whole, that New York City's at the forefront of challenging. The idea that we'll let you into the club, provided that you have means, but if you're poor, to hell with you, right? New York City is challenging that. There is a sharp reaction after the outcome of the 1968 political election, Nixon, and there is at that point a sense where the so-called great silent majority immediately recognizes that trying to address socioeconomic issues is a form of racial inclusion that many people are not ready for, not interested in. And there is a sharp reaction at the national level where, the demographic pattern of folks leaving New York City, to be very clear, I'm talking about wealthier folks generally, but they're for the most part whiter folks, now moving to what we now know as the Sun Belt. They're going to the Southwest, they're going to the South. Those patterns, they're withdrawing from the city. where that happens, the national government famously takes the view, we are not going to fund New York City and all of its obligations that it incurred to try to address race from a socioeconomic perspective, right? We're not going to bail out their union contract. We're not going to bail out what they're sort of trying to do in terms of social services programs. They're not going to bail out the affordable housing crisis. And instead, what the government does is takes the position, we're going to withdraw social services from parts of the city that are underperforming to sort of say, those are not worth saving. Overwhelmingly, there are the Black and brown segments of the city. Planned shrinkage is an intentional, racially informed attempt to force out, ignore, just make folks go away who are poor and brown, drive them out of the city, and then use the city as a reinvestment tool. That's a neoliberal paradigm. And it is impossible to understand planned shrinkage without appreciating that in the late 1960s and early 1970s, New York City had public policy, as again, this very generous, I don't want to call it generous to sort of accept the framing and terminology of neoliberals, but an adequately funded social services program, social policy that looked at, that understood structural exclusion. And so it was focused on socioeconomic realities. A large manufacturing base with unionized jobs that any person who was not educated, who didn't speak English very well, who was just sort of poor, jobs that folks could do and have living wages that could enable their families to transcend poverty, right? There's no way to understand, and the book that's particularly coming to mind is Fear City by Kim Phillips Fines, and Professor Phillips Fines at NYU, that sort of describes the exact reason why New York City was left to die is because it was a polycultural haven for a different sort of politics inclusion. And so withdrawing those services, trying to drive folks out to sort of create an opportunity for investment was about conditioning Black and brown bodies to sort of participate in the standard capitalist narrative, to not have a generous welfare state. Our affordable housing crisis, a long way of saying, is that there were just too many, at a particular period of time, too many Black and brown people who seemed to be benefiting from inclusion. And so in essence, to hell with them. And that's why that's why the patterns of the Bronx is burning was also, Bushwick was burning, was also low-income communities of color were burning. It was racialized. That's why the way out is so deeply racialized, right? That's why gentrification is, at a very simple level, clearing out Black and brown communities to sort of condition them to sort of, you know, allow for wealth, but that wealth is overwhelmingly white people who are from these suburban communities to where people fled in the 1970s, as they would describe it, or they left, who are coming back and now suddenly want to live in a cool, whatever hip city, and housing for other people has to be cleared on and created to make space for them, right? That's why it's just very much impossible to talk about this outside the context of race, outside the context of race and gender, to talk about it as not being racism and sexism, because it's structural. It is the government, it's a problem that was created by social policy, and the folks who are reacting to the social policy, right? Kim Phillips Fines tells the story of a Washington room where some of our favorite people, like Don Rumsfeld, at the time a White House advisor, is sitting in a room with Gerald Ford, and Gerald Ford is expressing sense that we can't just completely not fund obligations. That's not, we can't do that. And Donald Rumsfeld essentially is saying, of course we can, who cares about them, right? We can totally do that and let them declare bankruptcy. We're not gonna bail them out. And it's impossible to understand that outside of racial tones. And I was gonna say the last way that that is true, and why we sort of harp on this, and why the conversation, everyone sort of reflects on the 65 Act and sort of in this context, attacks the model minority as being pernicious the model minority idea for me being so pernicious in opposing attempts to address the affordable housing crisis for what it is. Lee Atwater, Nixon's operative, famously had an interview in 1981 where Lee Atwater was sort of talking about, you can't say the N-word anymore in the late 1960s, 1970s, right? But you have to, what do? You have to make it so abstract. You got to talk about stuff like states' rights and how busing affects that. And you sort of have to elevate it to a level of discourse. So everyone's like, yeah, you know, federalism does matter. When you're really talking about is we have a problem with a social policy that would be inclusive on poor people on terms where poor people are thought of as social citizens. They don't need to be disciplined into, you know, capitalist productive bodies by sort of saying, we're not going to give you any social support, just figure it out, figure your way out, do all of this sort of, you know, the bootstrapping without boots idea that is at the root of how certain people celebrate the API community, right? Like the idea is always like, oh, people are so poor, but they work so hard and they sort of transcend, despite the fact that that's overwhelmingly not true, because that's just not true of anyone. Everyone requires resources for the most part. And so, yes, that's why the affordable housing crisis, that is the structurally racist and sexist roots of it.
And, I would just add to that. I think that Greg did an excellent job, contextualizing it. And I think that one last thing, that point that he made, which is very famous words by Dr. King, of how can you talk about bootstrapping when you've taken away a man's boots, really describes in very simple terms what social policy has been in the United States for the last 60 years, right? In every context we saw it. I mean, Greg is using an example of Nixon and Atwater, but think about also in the criminal context, right? The way that the criminal laws and the drug laws were talking about, the war on drugs, mandatory minimums, all the way that we began to define all of these things were just racially coded language to effectuate the same things of taking away people's boots, of creating a clear system of racism and racial hierarchy, but without using those words after the Civil Rights Act and the Fair Housing Act in the 1960s. You saw it in the criminal context over the last 60 years. And I think you saw it in the same way in the housing context too, right? Because Greg talked about it. You found ways to redefine public benefits and public goods in ways that made them seem, using words like handouts, or welfare queens, or as Bill Clinton used to say, at the end of welfare as we know it. All of these things were deliberate efforts to restructure public goods and benefits in ways that allowed the government at the federal, state, and city level to, as I said before, systematically disinvest in communities of color, and then use those disinvestments and use the harmful impacts of them to further justify in a circular way further disinvestment and further stigmatization and racism. In the housing context, if you think about it, the way that we, public housing back in the 1950s was some of the best types of housing that we had in New York City. It was largely white and middle-class housing, and it was well taken care of and well invested in. But as white flight happened in the communities that we've talked about, the decision was made to stigmatize public housing, to take resources, investment out of it, and by bleeding it of all of those things, create problems of severe neglect, and overt or benign, whatever you want to call it, and then justify, after you've taken out all those resources, what they called urban renewal or slum clearance. The very problems that you created in the first place, address them in these ways that further excluded, displaced, and discriminated against poor people of color. So to this day, that's still a problem, because the lack of investments that NYCHA has, the way in which our public housing has some of the highest rates of lead paint in the entire country, was not just an accident. It was because the city simply stopped putting resources into them, stopped funding programs that created them in the first place. And you saw in other ways too, back in the 70s and 80s and into the 90s, there were actually programs that allowed tenants who lived in buildings that were abandoned by landlords to eventually take them over and purchase them as low-income tenant cooperatives or low-income co-ops that, you know, in the neighborhoods, some neighborhoods that we've worked in, were the first places in New York City where the concept of low-income or working class communities of color home ownership, where that started in New York City. But then those programs don't really exist anymore. Over time, they were phased out. The regulations on them became so onerous where if you can't pay your water bills or your tax bills, things that are difficult to do already as it is for low-income people, then the city could, you know, transfer those homes and ownership of those co-ops to, and bring in new landlords who would come in, or new models of ownership. But again, it's the same notion of these programs that were actually created to encourage home ownership, to encourage quality housing in communities of color, were stripped of all of those things, and then those things used as ways to further justify further disinvestment. And that characterizes, as Greg put it, so many different struggles we face that are all connected. But in particular in the housing struggle, a lot of the questions that we asked today about, well, why, where is the money to invest more in public housing, or why should we, or public housing has, you know, all these stereotypes, high crime rates, or things like that. I mean, these were all invented concepts to justify the disinvestments that have made in housing. And I just think that, you know, when we think about these issues, you have to zoom out and take that larger view and know that history too. But that is the history of racism in housing. And sorry, one last thing I'd just add is that's all that's happening on the one hand. And now on the other hand, what makes it even worse is these same neighborhoods now are neighborhoods where market forces are so unregulated and out of control that there's this added incentive to do further damage to get poor people of color out of housing, to bring in wealthier, whiter tenants who can pay far more, remove housing from rent stabilization. It's really a race to the bottom, but you've got this historic legacy of racism now coupled with policies, private development, rezonings, and market rate forces that have extremely harmful racial impacts as well. And they're only happening in certain neighborhoods, right? De Blasio's rezonings were only in poor communities of color. We weren't talking about the Upper East Side or the Upper West Side or Soho until very recently. But that is the way in which prior laws and policies have now had an impact on current policymaking, given the market forces and where they are.
Given, you know, really the historical, then social, political, legal constructs based on race that have really confined low-income tenants to certain neighborhoods, to certain socioeconomic statuses, how do you break down those walls, and why is it that you have chosen community lawyering to really address these issues? And can you talk about how maybe some cases that you have worked on that addresses it, not just on a very individual tenant level, but on a city or statewide level, where you can really address these issues, just not really confining your perspective to as a one individual low-income problem, but rather, as you and Greg addressed, as more of a historical and intentional, really racist policy that you really need to see and address to really make changes for these tenants.
So is that from, you want me to go first?
Sure, you can go first.
Sure. Well, I think for the reason why, you know, in terms of community lawyering, why that's so important is something that I do think that all of us as lawyers in this room, we have to really come to terms with in a far better way, is that, you know, I think there's a tendency for all of us as lawyers to get very wrapped up in what the laws may be, what the litigation strategy may be, and what result that may produce in the courtroom. And while there's a role for that, I think what gets really ignored and unaddressed by all of that is that none of those things will matter in any way if they don't actually have an impact on the ground. And if they don't actually aren't implemented, whether it's the laws themselves or the court victories, whatever you may call them, or decisions that we get, are not actually implemented on the ground, they mean very little. And I think also recognizes that the court system itself is very disconnected from the lives of ordinary people, and especially poor people of color. I think, when you're representing corporations or, larger companies or in the private sector, the courts can be but can be more of an arbiter of what's fair, what's right, what rules govern a contract, how do we, arbitrate this dispute. But in the context of the work that we do in legal services and the housing movement, the courts are part of the problem. The caseloads are enormous. The courts themselves are, very can be very one-sided in the way they apply the law. And that's not just, some biased perspective, but it's until very recently, until right to counsel became a reality in New York City, and there's a lot of issues that to work through, but until that was the case, over 90% or 94% of tenants in New York City did not have a lawyer when they went in the courtroom, whereas the vast majority of landlords, had lawyers. And so from the very beginning, when you walked into housing court, there was this fundamental disconnect between a fundamental inequality of representation in the courtroom. And the caseloads are enormous. And so the judges oftentimes want to get them as quickly as possible done, which incentivizes settlements and settling cases over things that there shouldn't be settlements over. Or if there is a settled agreement to fix hot water in 24 hours, if that's not done, there should be real consequences behind that, because these are basic rights, civil rights, that should not be kind of cabined to a piece of paper in a settlement agreement. But the court system is set up to incentivize that. And then on top of that, many clients and tenants of ours, they come into the courtroom and they're waiting hours and a full day for their case to be heard, if it's even heard. And oftentimes it's an adjournment after waiting all day because there's just no time to get to it, or the judge wants to put it over to another day. Or there are trials that there are statutory mandates that they happen quickly with few adjournments because of how urgent the conditions are. But in those situations, the courts delay in willful violation of the statutes, delay these proceedings for months, which means that conditions that existed in the winter, by the time you go to trial in the spring, have already changed, may not be conditions anymore that exist. And so, you have rights violations that just are perpetuated by a court system that is simply unresponsive to them. All the while, tenants who are low-wage workers cannot take off that time from work, cannot find childcare for their kids, and just spend and waste so much time in the courtroom. And it's I can feel it, because we all know it. It's just that it's so angering to see that, because these are your clients who cannot take that time. And this is how systematic the system is, one of attrition that wears them down. So community lawyering, and the last piece of what I mentioned before is that after all of those struggles, you may get a piece of paper and a victory that the appellate division then affirms. But in far away from the courtrooms, in Bushwick or in Elmhurst or in Flushing, the landlords feel that they can operate with the level of disconnect from the court system, and then whether or not they enforce those laws or not, whether or not they will repair the building or not, or say, oops, I cut off hot water by doing construction work to repair your issue, now you have no hot water. Those things happen unaddressed, no matter what the courts may say. And so where community lawyering becomes really important is a recognition that the courts and litigation are only one tool that we have, that not only that we have, but we must have in a much larger array of tools, because the courts are part of the problem. They're not the answer. And it really recognizes that is the case. And it recognizes that these struggles are actually taking place in the communities that we serve. And the biggest part of it is to, one, combine organizing with lawyering, to work with organizers on the ground that can help bring tenants together. So instead of one tenant facing an eviction case, you have 20 tenants on a rent strike that are hurting the landlord economically, where he has to respond to them. Or a number of tenants who say, we are all signed up under the law that, as a statute requires, take the building away from a landlord. We have the numbers to make that petition in court. And community lawyering, I think, harnesses and recognizes that reality of combining these out of courtroom strategies, including in the media, including with our elected officials or the advocacy tactics, with litigation in the courtroom, and just stems from that recognition of that. And so, I think that is what drew us to this work, because at the end of the day, we're not concerned about legal wins or victories on a piece of paper. We're actually concerned about making a tangible victory or achieving justice in our clients' everyday lives. And that human aspect of it, I think, is very central to community lawyering. I know, Lina, you asked for examples, but maybe I'll just stop there for a minute for Greg if you want to jump in, and we can talk about examples of that too.
Sure, I'll tell two stories. Now, one that Shekar alluded to, I'll give in sort of older version. I'll give the modern equivalent of, I think, that story. Shekar talked about these low-income tenant cooperatives. So the story goes, it's rooted in continuing on my narrative about planned shrinkage, right? So the context of planned shrinkage, landlords trying to get out of New York's regulatory scheme in the 1970s, decide that it's more worthwhile to them to get insurance money than it is to maintain the building. So they set the building on fire. Tenants are part of that resistance. As a community lawyer, you have to be, if you're rooted in a place, right? If you look at that as an individualized case, all you're doing is sort of saying, you might even address at best the potential arson, you bring a tort case. What a community lawyer does is understanding that socioeconomic context, they're rooted in the communities, and so the practice, again, involves here in New York City attending in modern times these local community board meetings, being there with folks on the ground, organizers on the ground who are talking about this dynamic. They're seeing a pattern of folks coming to the office. So when you've done that, you recognize that this is a socioeconomic structural problem. Landlords start to abandon these buildings. The city needs property tax fund. They just want the property tax to be paid because under the law, when a landlord abandoned property becomes property of the government. So now folks are living in government housing. You're noticing, you're talking to the tenants, you understand that dynamic. The next move is you advocate with the city, you get a collective together and you sort of say, city, you have a problem called you need property tax money. Our clients would like to ensure that if they are taking care of and investing their labor into maintaining the building, they get something for that. They have sweat equity. That devises a program that Shekar talked about, these series of programs that gave various levels of distressed buildings to tenants either or to nonprofits. That's the 70s and the 80s, you've won that battle, right? You're maintaining the buildings into the 80s, into the 90s, right? Then the era of gentrification comes upon you. When you understand that switch dynamic, where now, and a particularly a market force, the reality that people who are income poor on paper, but asset rich, hint, hint, the people who are part of the flight from the cities program into the or reality, have accumulated wealth, they are coming back to New York City because now everybody wants to live here as the center of the world. You now have a dynamic where those folks are trying to buy into these low-income cooperatives that are now extraordinarily valuable in the sense that they are part of a city where folks want to live in, but they're still much more affordable forms of home ownership, but they're not intended for people who clearly have means. They're just income poor on paper for whatever reason, whatever it is that they're doing, but they have family wealth, right? And so in that context now, the struggle is pushing for a series of reforms to the city to sort of say, city, enforce the rules. There are rules about these low-income cooperatives, right? The city just manifestly refuses to do that. So that's tenant meetings, tenant campaigns to try to, that's what community lawyering does. It adds a dimension to this where, again, you're not just litigating the individual case, even if you're representing the individual cooperative, where you're trying to help them, if they so choose, to structure themselves in a way that they can resist individuals who are trying to corrupt this program, the new problem that you now have after having survived through planned shrinkage. You're not just trying to do the individual cooperative, you're understanding that this is a larger social policy problem, so you could get a part of coalition work. You are trying to get legislation, you're trying to get city enforcement. All of that comes in the context of abiding with individuals and understanding the nature of the problem. because you've lost. As great as the low-income tenant cooperative program is, you've lost if 30 years later, it's all wiped out, right? And to sort of give the modern case that also talks about a community lowering struggle that we all were a part of. During the heyday of gentrification, Shekar was quoted in an article about The Nation that was describing this program. We now had, again, it's the more things change, the more they remain the same. Gentrification brought the Bronx is Burning problem 2.0, called the landlord destroys the building, because there's such a thing called, on the ground, eviction by building code, by government code. If you destroy the building enough, you can trigger the landlord, the city coming on saying, you tenants cannot live here in this building, it's condemned, the tenants leave. That's exactly what the landlord wants. It's even
Which is completely illegal. Completely illegal.
So totally illegal, always is legal, but did that and created this perversity. It became an economic model. In the hot gentrification market, what we came to learn in the process of litigating these cases in North Brooklyn is there was a real estate conference every year where real estate executives would describe exactly this, how to use the building code to get tenants out and flip a property in a way that rent regulation would not allow you to, right? So being on the ground, you can litigate an individual case. But again, part of the practice, being at these community board meetings, abiding with tenants, talking to organizers who identified patterns of this. You had lists of private equity. With that private equity, you would do things like check the mortgages and realize, oh my goodness, there was a clause here in the mortgage that incentivizes a landlord, if they can flip the unit, make it a market rate unit under the law as it existed at the time that was sort of perversely allowing this, they get some savings on their mortgage, right? So they have an actual financial incentive to do this. What did that lead to? That led to a campaign called a two-part campaign that allowed us to change the way that the building code operated. It was called the Stand for Tenant Safety Campaign. It led to some changes in both the housing code that sort of created, that made that form of harassment illegal. And it also involved building code changes that, instead of just the way that the building code worked, because again, when you're abiding with tenants, when you're plugged in, when you're not just looking at it as an individual case, but you understand the context, you understood that the city itself was captive to neoliberalism, right? The building code, to facilitate development, had been changed in the 1970s to allow something called self-certification. The landlord was allowed to just sort of say, I'm following all the rules, and check a box. That led to absurdities where landlords are doing things outside of code. Hence, that's how you had the destruction of the building. Changed those laws. The city also took the position that if the building code violation happened, they just had to condemn the building. They had to, or really order that the tenants leave, order to be vacated. But they just sort of said, that's all we have to do. The legal campaign led to a change that then said, if the city vacates the building, the city has to explain what is wrong and give a timeline for the landlord to fix it, in a way suggesting tenants have rights here too. It's not just a question of, to Shekar's point, urban blight we're trying to get rid of. It's a sense of, no, there are rights here. That campaign led to a full legal reform. The last piece of it is that campaign joined longstanding years of effort to change the laws on rent regulation to then destroy some of these perverse incentives to destroy buildings by eliminating the idea of what was called high rent decontrol, the idea, or deregulation, that if the rent for a unit went over a certain amount, the building would be taken out of rent stabilization. We eliminated that. That was a piece of it. That's what winning looks like, right? Because if you have an individual case, you have a narrow focus, you might win your particular eviction case, you might win your particular case for repairs, but you will lose in the long term, because so long as these conditions obtain, your clients, we always used to describe, Lina would say this, Shekar would say this, we all would go to clients and say, you have a target on your back. The landlord you own something or you have something, the society won't regard you as owning it. A rent regulated apartment that your landlord wants irresistibly, right? And so until you change the context, to remove that target, you're going to lose. And the only way you know what to do is to be in the community, be living there, rooted there, talking to people on the ground there who could sort of say, this is not a problem merely of, exactly what sort of Shekar says, right? What we've come to appreciate in the Donald Trump era is the law is not merely just a statute, nor is it even the regulations that the agency enforces. It is the organs of enforcement. If a court, because a court has 6 conservative justices, doesn't give a crap about Roe versus Wade, that's functionally abolished. If you can't get an injunction to enforce Roe versus Wade, doesn't matter. The same reality with the tenants. If you have on paper, it was illegal then for a landlord to destroy a building. But if you have no enforcement mechanism, if you cannot sort of say some way to breathe life into, to make that thing have teeth, to make the thing actually matter, you will lose. And the only way you will appreciate that is if you are not merely a lawyer who is sort of saying, this stuff is on paper, but you are rooted in reality. The stuff's on paper, but the lived experience that I'm hearing on the ground, I'm hearing in these community meetings, I'm hearing with these organizer folks is the enforcement organ doesn't care, then you will lose. And the whole point of community lawyering is exactly designed to our type A personalities as lawyers who are competitive is a great thing. We're here to win. And winning means the communities stay intact and can thrive. It's not about pieces of paper. And the good news is we were ahead of the curve. Everyone now finds a crisis of paper. Everyone's shocked. And I use that, oh my goodness, super precedent from the Supreme Court doesn't matter anymore. And all of us would have told you that, all of community lawyers would be like, of course it doesn't. Because you know where that was lost? That's lost where you lose it in the Senate committee room where Mitch McConnell can outflank you. It's lost. It's lost in sort of the general narrative in terms of not understanding that dynamic, not being rooted, not knowing who this person is, and being a justice who is from Brooklyn, went to James Madison, doesn't understand you gotta resign, you gotta go. Because if you don't do it, nobody is gonna abide by your wish that nobody replaces you after you're dead, right? This is sort of stuff where that practice of understanding what happens actually on the ground, not just the paper, not our venerable institutions, is the difference. And as for poor people, it is the difference between losing and winning, actually, right? You can have everybody has all their papers or these Smith's cases, but if 5 years later, a year later, really, your client's driven out because of these macroeconomic dynamics that you did nothing about because you didn't understand them, you lost. And that's what community lawyering is meant to prevent.
Thank you, Greg. I will leave some time for Q&A. So please start submitting your questions on the Q&A button now, if you can. But I do want to, and Shekar, maybe if you can talk about an example very briefly, perhaps Broadway Triangle. And I do want to turn over back to you, Shekar, and Greg, because you have built on community lawyering and have now, really, chosen the politics and education to really give back in a formative way that I think is very unique and something that I think a lot of law students and lawyers would be interested in learning more about. So I am going to stop you around probably 10:22, but once I start getting questions, I will open up the Q&A session. But if Shekar, you can go first, and then Greg, if you can jump in after, and then we'll go into Q&A.
Sure. I would just say quickly, one of the cases that Lina mentioned was a Broadway Triangle fair housing litigation, which similar themes that Greg talked about in his examples was a larger fair housing community struggle in a different, vein of our work, which is representing coalitions and communities in struggles against discriminatory rezoning and development tactics. And that was a coalition where we represented over 40 community organizations fighting a rezoning that violated the Fair Housing Act. And we represented churches, public housing projects, tenants, tenant associations. And we really showed the way in which, one of our theories that we brought the case under was a perpetuation of segregation theory under the Fair Housing Act, where the city, in violation of certain sections of the Fair Housing Act, was not studying the way in which its rezonings would perpetuate segregation and further exacerbate the inequalities that our clients were facing. And we ended up getting a very victorious and major settlement that set precedent across New York City that's now been codified as law in the racial impact studies that have passed the council as legislation. And that just kind of gives a broader lens of the way we in community lawyering see our work, right? It's not just the individual case, the individual instance of housing discrimination, but bringing cases that even advance novel or different theories under fair housing laws, like perpetuation of segregation, and forcing the courts to think about these cases in a broader lens of how a rezoning can actually do much more damage to a community than simply just the property or the site where it's located. And that's now become more and more common theme in New York City. We're talking about rezonings, like the whole notion of a racial impact study was to force the city government to think about its development practices in those terms and think about that as a issue of fair housing justice and what the Fair Housing Act requires, given its broad legislative intent. That was a case that lasted 10 years roughly before we settled it. But it certainly has really introduced a new dynamic into conversations about housing lawyering and housing justice in the city. The last piece I just add for me is it's a huge, I think for Greg will speak to this too, but a huge step for us from here. I think Lina phrased it so well as, building on the work that we've done in community lawyering, but I don't think we see ourselves as leaving that work in any way. It always stays with us. It's central to who we are. Politics for me, I saw as a path to addressing some of these things that we're talking about. And I've seen it now where some of our colleagues have said, we're so glad that you're there because we can talk to you about these issues and find ways to introduce them into our political dialogue. But I'm under no bones that the most important, I'm under no disagreement that the most important work is happening right here in the community lawyering work that we do. And that's something that'll always stay close to me and illuminate a lot of the work that I do now. It's those lessons that I take with me to talk about these issues in the political realm too. But that's how I see it. And I see it as really, keeping close to the principles that we fought for this entire time too, and trying to uplift them more in a realm of government that we've not had that kind of discussion before.
So it is 10:22. I just want to take this time to answer any questions. So one question that we received is any comments about how the pandemic rental assistance is or is not working and how it doesn't seem to be getting to people. Do you and Greg want to speak? This is the ERAP program.
Very briefly, yeah, I think it's not working because this is the community, two aspects I would say. This is the community organizing dimension. Number one, if there's no infrastructure for getting the word out and working with individuals to come and apply, you have a problem, right? That's sort of the fundamental idea. There's no way to reach many communities who are meant to be eligible and sort of explain the requirements. Number two, this is the other community organizing problem. There have been jurisdictions around the United States where essentially the federal government, the ultimate source of this funding, though in New York, there are different pots because we also provide rental assistance to individuals who are ineligible for federal funds get based on the immigration status, right? Regardless, federal government's basically taking the position, please get the money out. And so have invited people to eliminate some of the requirements along the lines of most pandemic assistance. Like if anyone's familiar with, to give an analogy that I could think of, some of the assistance that's been given to small businesses, pretty much with some small businesses, you just have to check a form that says like, I need it, and they give you the money. Whereas here, because we are so entrenched in the poverty paradigm, and choosing poor people, you have to check all the boxes of all the eligibility crap. So the other piece of this is because there's a lack of community organizing infrastructure, or we don't have data specifically on the communities that are most affected, the API ones here that could be marshaled to say, look, simplify the process. You have to simplify the process. And that's the sense in which it's just not working, right? We don't have ways to get out the word. We don't have ways to help folks. And the other thing that would be the benefit of sort of having this, helping folks with facts on the ground, as facts on the ground would change the program to simplify it in a way that we have been doing this with all forms of pandemic assistance. I mean, it's nothing new with the self-certification. That's how the Restaurant Revitalization Fund works. That's how the PPP loan started to work. But it's just that since we hate poor people so much and we just don't trust them, we still have, here in New York, we still have that infrastructure, and that should be relaxed. So that's related to the theme, but that's essentially the problem.
Shekar, do you have anything to add to that?
I would just add that, I think it's just very reflective of, the larger themes that we've been talking about too. We have this program that the government set up after much pushing and much pressure, but many tenants have not been able to access it. It's the funds they've stopped accepting applications, in terms of adding more money to it too. It's like their expiration deadlines. We've constantly had to fight during the pandemic for extending the eviction moratorium. It's very reflective of the way in which government doesn't actually invest properly in these programs. And then again, if that's the case, then most people can benefit from them, right? And it's very similar on a separate note to the excluded worker fund too, which is the same exact thing. It stopped accepting applications. They've run out of money. They weren't able to pay as many people as they promised, the applications that came in. And so it's just, it's just very, it's another symptom of the problem that, even when we need in these situations, we need to be doing more for tenants, and the mandate is very clear to do more. Some of these same problems still exist, and I just think that it's very disappointing to see that.
Thank you, Shekar and Greg. So we do have a couple of minutes. I think we have time for one more question. So we are running out of time, but if you have any questions, please feel free to put it in the chat or press the Q&A button. But just as a reminder, if you are getting CLE accreditation, please complete your evaluations and return it to CLE@abany.org. And those who will be attending live sessions at King and Spalding on Friday, you need to sign in and out and complete the written evaluations. So I'm just gonna open it up again. If anyone has any remaining questions in the last 1 or 2 minutes that we have left. Okay, otherwise, I just want to really thank Shekar and Greg, and it's been such a pleasure, obviously, working with you and really getting to this point. And I really appreciate you taking the time and talking about this. And I know that this is so informative, especially for law students and attorneys who are really thinking of different ways to give back. So just a question about the CLE accreditation. It's one there were two codes. And let me see. Okay, so I will be typing in the chat the code. 1 second. Okay, so I just typed it in the chat to everyone. But thank you everyone for joining. It was such a pleasure, even though it's through Zoom, seeing everyone. And if you have any more questions for us, please feel free to reach out. But otherwise, have a rest of a wonderful conference, and hope to see you again in both. And thank you again, Shekar and Greg.
Thank you so much, Lina. Thank you so much, Greg. Friends, I was gonna say, if you wouldn't mind putting, let's get one more picture. I think we were all very serious before, so we want us smiling with the if we can, Francis, with the that slide up too. I'd love to capture this moment. All right, let's get the okay, ready? 1, 2, 3, smile everyone. One more. All right. Thank you everyone. It was so nice to be on this. Thank you all so much.
Thank you, everyone. Thank you.
Thank you very much.
Bye everyone. Thanks so much.
Hi, everyone.